Friends, I welcome you all at Swayam platform. I, Dr. Anup Kumar, Assistant Professor, Faculty of Law, Banaras Hindu University. We are here to discuss a course on Hindu personal law, including marriage and succession. We are in the week first, where we are discussing about the meaning, concept, and application of Hindu law. Today, I am going to start my fifth lecture on application of Hindu law. Before starting the today's lecture, I want to focus on previous class. In the last class, we understand who is Hindu as per the law. Because today's topic and the topic of the last class are somehow connected. Because the application of Hindu law is totally dependent on the definition who is Hindu. Because Hindu law is personal law. Therefore, in the last class, we discussed that who is Hindu? A person who is following Hindu religion. A person Buddha, Jain, Sikh is also comes under the domain of Hinduism, and a person who is domiciled in the territory to which the act extend and who is not Muslim, Christian, Parsi and Jews unless otherwise proved will considered as Hindu. Child whose both of the parents Hindu, then child is Hindu, one of whose parents then child brought up as Hindu, then child is Hindu. Any person who converted and reconverted in Hinduism is also considered as Hindu. And section 2 subclass 3 focus on that how we can construe the term Hindu. Now I want to focus on the today's lecture on application of Hindu law. Friends, the learning objectives includes first the application of Hindu law, territorial application of Hindu law, and the meaning of the term domicile. These are the three fundamental objectives of today's lecture. Now friends, I want to explore the idea of the application of Hindu law. The application of Hindu law may be explained on the basis of the classification of legal history of India. Because without classifying the legal history of India, we can't explain the idea of the application of Hindu law. We may categorize the entire legal history from this perspective into the two broad category. The one is before the codification and after the codification. So therefore, I want to start my discussion on application of Hindu law before the codification, which is prior to 1955. The traditionally rulers apply Hindu law which were developed by the sages and written by the commentators and digest writers. The important point is the seminal work of the Kautilya, Arthashastra, was applied in administration of justice during the ancient India. When Britishers came in India, they were not willing to intervene in the social and religious matter of the Hindus. Therefore, they applied Smriti, commentary and digest in the reference of Hindu personal affairs. And before the independence, the Privy Council and the Court of India extensively applied Manu Smriti and commentaries on Yagyavalkya Smriti, that is Mitakshara and Daibhag, for the adjudication of the matter related with Hindu personal law. The Constitution of India came into the existence in the year 1950, which introduced new legal regime in India, and the Constitution laid down very fundamental principle in the form of Article 372 of the Constitution. And 372 is very crucial in this regard because Article 372 laid down a principle that all the laws in force in the territory of India immediately before the commencement of the Constitution shall continue until altered or replaced or amended by a competent legislature or other competent authority. This is the fundamental principle, and therefore the Article 372 is enabling provision which enables legal authority to continue with those laws which were prevalent prior to the independence. So we must understand the application of Hindu law before the codification and after the codification. Before the codification, the ancient time, Hindu law applied by the king, and during the British era, they also applied Hindu law in the reference to the personal affairs of the Hindu. Indian courts and Privy Council extensively used Hindu law for the adjudication of the matters related with Hindu personal laws. This is the point. And now we should focus on a contribution of constitution in the form of article 372, because 372 provides a clue that how you can continue with your legal tradition. The contribution of article 372 as a bridge to connect the traditional law in a modern context, and therefore tradition is continue in modern time. Now I want to focus on the application of Hindu law after the codification. After the codification of the major branches of the Hindu law in the form of 4 different legislations during 1955 and 56, the idea of applicability of Hindu law substantially changed. The major branches of Hindu personal affairs is now codified in the form of 4 legislations, which includes Hindu Marriage Act 1955, Hindu Succession Act 1956, Hindu Adoption and Maintenance Act 1956, Hindu Minority and Guardianship Act 1956. These 4 legislation change entire context of the Hindu law. After the independence, the parliament tried to introduce a comprehensive legal code which popularly known as Hindu Code Bill. Although the idea and spirit of Hindu Code Bill has been reflected in the 4 above mentioned legislation, but due to the political crisis, Hindu Code Bill was not introduced that time. But the idea of Hindu Code Bill gradually accepted in the form of different legislation in India, and it is applied nowadays. Therefore, friends, enactment related with Hindu personal law is considered by the scholar as a unification of personal law in India first time, because number of diverse community residing in India, they have different practice, they have different rituals, but now they are governed with legal rules. Therefore, a codification for which we are trying and still we are trying, but a codification already happened in the year 1955 and 56 for the majority of people of India. Now I want to focus on section 4 of the legislation mentioned above, laid down 2 fundamental rules, because every enactments include section 4 and more or less gist of section 4 is same. The rule is, first is, the text or interpretation of Hindu law or any custom or uses as the part of Hindu law in force immediately before the commencement of the codified Hindu law shall cease to have effect, and any other law in force immediately before shall cease to have effect. Means Shastric Hindu law which was prevailed before the enactment shall cease to have effect, for which the provision is met, and any other law which is contradictory to this act also have no effect nowadays. Means friends, these fundamental provisions that provides the scope to apply traditional Hindu law, customary Hindu law, as well as the Hindu law developed by the commentators and digest written. Due to these provisions, continuity of Bharati legal tradition still exists. I want to focus on the section 4 subclass A in order to explain my entire thesis and idea, friends. What is the ultimate impact of section 4 subclass A? Section 4 subclass A laid down the clear rule that any textual Hindu law, for example Manusmriti, Yagyavalkya Smriti, commentary and digest, or any interpretation of those textual law or any custom or uses as the part of classical Hindu law, the above mentioned shall have no effect on contemporary legal system because of section 4 subclass A of the Hindu Marriage Act. But section 4A also opens a scope to apply the traditional Shastric law because it uses a specific phase for which the provision is made. Means, for those area where codified Hindu law is silent about Shastric Hindu law, then Shastric Hindu law will apply it. Therefore, in the last slide, what I discussed with you, I discussed with you that due to this provision, for which the provision is not made in this act, we may inculcate the Bharatiya tradition of law in contemporary era. By this discussion, we are able to understand the application of Hindu law before the codification and after the codification. Please understand again. Before the codification, Shastric Hindu law, textual Hindu law applied on Hindus. Britishers also applied on Hindus. British courts are also applied on Hindus. 372 provides you a scope to continue with your traditional law. Therefore, after the independence on 15th August 1947, still we continue applied Smritis, commentary and digest, especially Mitakshara and Daibhag, for regulating the personal affairs of Hindus before the codification of the four major branches of the Hindu law. This is the fact. And after the codification, we developed the thumb rule in the form of section 4 subclass A, which concludes that all the Shastric law, interpretation of Shastric law and custom shall cease to have effect for which the provision is made. Means for which the provision is made, Shastric law have no relevance, but simultaneously it open a scope for which the provision is not made. For which the provision is not made, entire Shastric law is still become relevant. Friends, I am bound to conclude that this code is not comprehensive code, because family matters are too diverse and therefore we are not able to conceptualize, codify each and every dimension of personal life, and therefore still today we are able to apply Hindu law which was mentioned in our custom, in our Shastric tradition. Now I want to focus on the application of Hindu law in contemporary legal scenario. This is another different perspective to deal with the idea of application of Hindu law. The application of Hindu law may be classified on the basis of dharma of man and another on the application on the basis of the territory. Now I want to summarize the discourse with the application of the Hindu law on the basis of dharma. Hindu law is a personal law which is laxatory in nature. Therefore, Hindu law will apply only to Hindus. The term Hindu may be according to the rule laid down by section 2 subclass 3 of the Hindu Marriage Act, where section 2 subclass 3 mentioned that the expression Hindu in any portion of this act shall be construed a person to whom this act applies by virtue of the provisions contained in this section. Means for the purpose of application of Hindu law on any person, you must be Hindu in the eye of law. Therefore, the Hindu law shall apply to the Hindu only as defined by section 2 of the act. Now I want to focus on the application on the basis of the territory. This idea may be explained on the basis of section 1 of the Hindu Marriage Act, especially section 1 class 2 of the Hindu Marriage Act. It provides that Hindu law extends to the whole of India and applies also to the Hindu domicile in the territory to which this act extends, who are outside of the said territory. This is the idea which is mentioned in the form of application of Hindu law in terms of the application. Now the territorial extent and applicability of Hindu law. Hindu law is not lex loci, means law of locality, means the law applies only to the particular locality or state, but it applies to a person who is Hindu irrespective of the territory in which he or she reside on the basis of domicile. Means, friends, what I want to say that the entire application of Hindu law may be broadly categorized in two broad categories. One is the interterritorial operation and another is the extraterritorial operation of Hindu law. Friends, Hindu law applies to Hindu domicile of India or territory to which this act extends, who are the resident of the said territory. This is the point. Interterritorial operation and extraterritorial operation of Hindu law. This is the 2 point which should be focused on that. Now I want to focus on the section 1 of the Hindu Marriage Act, which talks about the two things. The first, it extends to the whole of India, and second, extraterritorial operation of the law. So now I want to discuss the interterritorial extent of Hindu law. Friends, the interterritorial application means the application of Hindu law within India. This application is not controlled by the concept of domicile. A person who is residing in India and is resident of India will be governed on the basis of the fact that whether they are Hindu or not. For example, a Nepali Gorkha residing in India and describing himself as a Hindu, then their marriage may be governed by the Hindu Marriage Act 1955. Further, the application of Hindu law is dependent only on the fact whether he is Hindu or not as per section 2 of this act. Friends, I want to say you that interterritorial application of Hindu law means application of Hindu law within India. For the purpose of application of Hindu law in India, we will only focus on who is Hindu. If we able to determine a person is Hindu, we will apply Hindu law on them. There is no other requirement. The interterritorial operation of Hindu law is totally dependent on the status of a man, whether person is Hindu or not, as per section 2 subclass 3 of Hindu Marriage Act. If you are Hindu, it is proof, then Hindu law will be applied on you, because we accepted the vast range of the definition. Therefore, a person who residing in India and he describing himself as a Hindu, Hindu law may be applied on them. This is the interterritorial application of Hindu law. Now I want to enter in the different question, is the extraterritorial application of the Hindu law. The extraterritorial application of Hindu law mentioned under section 1 subclass 2, where the law provides that Hindu law applies on those who are outside the territory of India but they are domiciled Indian. Means you are residing outside in the territory but you are domiciled Indian. Means domiciled in the territory to which the act extends. Means extraterritorial application of Hindu law is applicable only on the basis of domicile. The nexus for the application of Hindu law here is not Hindu but Hindu domiciled in India. We must understand the difference between the interterritorial and extraterritorial operation of Hindu law. Interterritorial operation of Hindu law is totally dependent on whether you are Hindu or not, but extraterritorial application is totally dependent on whether you are domiciled Indian Hindu or not. If you are domiciled Hindu Indian, then Hindu law will apply on you. This is a connection between the domicile and extraterritorial application of Hindu law. Now, we should also focus on the power of the Parliament in the form of Article 245 subclass 2. The Article 245 subclass 2 laid down a principle: no law made by the Parliament shall be deemed to be invalid on the ground that it would have an extraterritorial operation. Means the competency of law is totally dependent on this very fact that law will apply beyond this territory. Means the Parliament has the capacity and competency to enact the law which may applied outside the territory of India. Therefore, section 1 clause 2 is correct as per the constitutional norm and this scheme. So what I want to convey that Indian Parliament have a capacity to enforce a law outside the territory of this country. On that basis, the law will be applied. Friends, and the power derives by the article 245 subclass 2, and Parliament exercise the power, and therefore Hindu law is applied beyond the territory of India on the basis of domicile. Now I want to discuss the meaning of the term domicile. The domicile means, domicile is that place where habitation of a person is fixed without any present intention of removing therefrom. Means the idea of domicile is very prevalent within the domain of the private international law. The private international law laid down the principle that the personal relations are subject to the law of domicile, and immovable property is subject to the law of place, that is where the property is situated. So when we are explaining the idea of the domicile, we are bound to think about the private international law, because private international law laid down the fundamental rule that personal affairs must be regulated on the basis of domicile, and immovable property must be regulated on the basis of the situation of the property. And therefore our Hindu personal law adopts the scheme of private international law. But very interesting fact is the application of Hindu law beyond the territory of India, although dependent on the domicile, but the term domicile is not defined and described by this legislation. In India, Indian Succession Act 1925 laid down a very vast provisions associated with the law of domicile, with number of illustrations how the law of domicile will be applied in a case of family matters. But I want to clarify that, friends, due to section 4 subclass B, any other law which is contrary to this law shall have ceased to effect, and therefore the law of Indian Succession Act 1925 not applicable in a case of Hindu personal laws. Now friends, it is established rule that the entire section 11 subclass 2 and domicile term is based on the spirit of private international law. Domicile includes two essential ingredients. The first one is residence of particular kind and intention of particular kinds. Means on the basis of residence as well as on the basis of the intention you may determine the domicile. The scholar also identified the general principles related with domicile. This principle includes the person can have only one legal domicile. The second, every person must have a domicile and cannot live without domicile, and domicile can be acquired by will or by desire. Domicile connects the people with territorial law. This is the point. On that basis we are able to understand the idea of domicile. So first we bound to think about the domicile, then we think about the application of Hindu law outside the territory of India. And therefore friends, we are going to explain a definition. Central Bank of India versus Ram Narayan, where Supreme Court noted that there must be factum, there must be animus. The residence need not be continuous, but it must be indefinite, not purely fleeting. The intention must be present intention to reside forever in a country where the residence has been taken up. Means on the basis of factum and animus, we will decide the domicile of a person. Your habitation, intention and fact provide you a status of domicile. In the Indian law, Sundar Gopal versus Sundar Rajni, in 2013 Supreme Court laid down the detailed concept of the domicile. The Supreme Court observed that domicile of three kinds: domicile of origin, domicile by operation of law, and the domicile of choice. In the present case, we considered only with the domicile of origin and domicile by choice. Domicile of origin is not necessarily the place of birth. The birth of a child at a place during the temporary absence of the parents from their domicile will not make the place of birth as a domicile of the child. In domicile of choice, one is abandoned and another domicile is acquired, but for that the acquisition of another domicile is not sufficient. Domicile of origin prevails until not only another domicile is acquired, but it must manifest intention of abandoning the domicile of origin. The private international law categorized domicile in three broad categories: domicile of origin, domicile of choice, and domicile by operation of law. This case is associated with domicile of origin because they are living in Australia, they have in dispute, and therefore wife file a case in Indian territory and husband try to counter by this argument that he is not living in India, he is residing outside in India, and therefore the Hindu law may not apply on them. But court concluded that so long as you not prove the abandoned Indian domicile and acceptance of domicile of other country, the law will apply on you, because burden of proof lies on your shoulder to prove that what is your exact domicile. So this is the case. The court further observed that the court will presume that the person is having the domicile of origin if husband argued that he has abandoned the domicile of origin. The burden of proof lies on the shoulders of the husband, that he proves how he abandoned the Indian domicile and how he accepted the domicile of other country. In this case, husband was not able to provide sufficient evidence to prove the fact, therefore Hindu law will apply on husband as well as wife in particular case. Friends, by this discussion we are able to conclude that we must understand the idea of domicile. If you want to apply Hindu law within the territory of India, the one important point should be taken into the account is whether you are Hindu or not. And if you want to apply this law outside the territory of India, then you are bound to think about that whether you are Hindu domiciled Indian or not. Now I want to focus on the conclusion. The primarily, friends, Hindu law will apply on any Hindu residing in Indian territory. The application of Hindu law outside the territory is dependent on the domicile. The Shastric Hindu law may be applied in contemporary legal regime in the context of the matter for which the provision is not made under the codified Hindu law. In those contexts only we may apply Hindu Shastric law on Hindus residing in India. Therefore, friends, after that we may think over that each classical Hindu law is still relevant. Think over that. Very interesting point for the discussion and discourse. And second, how Indian law may be applied outside India. You may think over that. By this, I want to conclude my entire summary of today's lecture. I categorize my entire lecture in two different contexts: application of Hindu law before codification and after codification. Before codification, ancient Hindu jurisprudence and ancient Hindu law applied by the rulers. Hindu law consider the law of kings of king. Subsequently applied. Britishers also continue apply Hindu law on Hindus. Article 372 play a very crucial role because it provides a scope to continue with your legal tradition, because any law which is prevalent prior to the constitutions may continue after the constitution. But after the codification, now scheme is substantially changed. Now Hindu law is codified and become uniform, and therefore due to section 4, the acts having overriding effect. Therefore, Hindu now governed by the 4 different legislations: Marriage Act, Succession Act, Adoption Act, Minority and Guardianship Act. But section 4 subclass A is still open a scope by using a terminology for which the provision is not made. Then Hindu law may apply on, Shastrik Hindu law still may apply. And after discussing this, I further discuss that the territorial application of Hindu law. Territorial application of Hindu law is dependent in the 2 contexts: territorial application within India and territorial application outside India. Territorial application within India is only dependent on whether you are Hindu or not, as we discussed in the previous classes. Your status provides scope for the application of Hindu law on you. But the second point is whether you, if you are willing to apply Hindu law outside the territory of the India, then you bound to think that whether a person is domiciled Indian Hindu or not. On that basis, Hindu law may be applied outside the territory of India. Friends, we must focus on Article 245 subclass 2, where the law is specifically mentioned that Parliament have capacity to enforce the law outside the territory of India. Therefore, the scheme of Hindu Marriage Act section 1 subclass 2 is as per constitutional norm. By this, I am summarized my entire lecture of today's. Thank you everyone for your patience.